Okay, everyone? It's okay, thank you. Thank you to all the shushers. Appreciate it. Okay, what we're going to be talking about is one of those collateral issues that's coming up more and more often, it seems, either from newly placed foster parents who are told by their FFAs to go ahead and file a de facto motion. We are getting them from, private counsel who come in. We're starting to see writs of supersedious filed in cases with the appellate court, and the appellate court allowing foster parents to go and look at the transcripts at the appellate court and review information which otherwise you would think is private under 827 of the Welfare and Institutions Code. I just wanted to know how many people here have been with Ladle 6 months or less? Show of hands. Okay. All right. So close to half of at least who's in the room. This is unlike the main issues of what do you do at an initial hearing or a judicial review. This is one of those collateral issues that you kind of need to at least be aware of. It comes up like paternity issues every now and then, but it's good to know because more and more we're getting new bench officers as well who don't really seem to know the law in this area. There are some who will make sure de facto parents have no say until after parental rights are terminated, but most of them that I see are, when I get sent over here, are allowing people to not just get the status of de facto, which needs to be shown only by a preponderance of evidence, but they're letting them have standing and full participation as if they were parties at, say, a judicial review hearing or disposition. They're not supposed to. And what we want to do is just make everyone aware that you should at least be objecting, putting something on the record, so that the writ attorneys in the office can take something up, or at least on appeal, we can start making arguments to the Court of Appeal that the extent of standing of some of these de facto parents is exceeding what the law really allows for. So again, it's not that we have enemies in the FFA or that minors groups are seeking foster parents to bring issues before the appellate court, but we kind of need to put an end to them, mentally at least. What I'm going to first do is give you a little bit of background on de facto parent status, where it came from. I think it important to understand the context so that when you do make legal argument in your court, you have some feeling for where all this came from. Back in 1933, there was a case called Guardianship of Shannon. There was a stepmom and the father living with 2 daughters. The biological mother hadn't really been involved with the family. These were young kids for about 5-6 years. The stepmom wanted to become guardian for the children at least, and so she brought a motion. The court used the phrase de facto parent status and decided that, as the law existed in 1933 at least, that this stepmom had the relationship, filled the role of a parent, and gave her the status and standing to participate fully in the proceeding, and she was granted custody of the girls, mom having not been around for a while, because she was the psychological parent and filled the role of the parent. Then California also came up with In Re BG. That's a case that you'll see cited a lot in the motions for de facto parent status and standing. In Re BG is a 1974 case. In that case, the Soviet Union had just invaded Czechoslovakia back in 1968. This was before it became Slovakia and the Czech Republic, for all your history buffs. So what happened, the father came here. Oh. Yes. So Dad, the father brought his 2 daughters, her son and daughter, to Munich he called his parents who lived in Yucaipa in San Bernardino County, and they made arrangements for him to come here as a political refugee, and he brought the 2 kids. Mom didn't know that he left. She was later informed by the grandparents that the kids were here. But in the meantime, unfortunately, Dad had terminal cancer, died. He left his mom by that time, wasn't really able to take care of the kids, so he left the children with a neighbor. And the neighbor, who got to be a foster parent after making application to the local Department of Family Services, petitioned the court and got an order from a court that she be the kid's foster mom and parent, the de facto parent. The court had given her full standing in the case. In the meantime, that was 1969. In the meantime, Mom had been informed that these proceedings had gone on. Through her attorney in 1971, she submitted to the jurisdiction of the court, so that took that issue away. But she did want custody back of her children. And so they all went to a hearing. They went up to the California Supreme Court, and that's where the court decided that since 1969 we hadn't had that spirit care. Hotel California. It's okay. For those who are listening. Thank you. The thing, yeah, I'll do Little John lyrics later. But what the court did was it looked at the standing. It recognized that there was such a phrase as de facto parent standing from the case of guardianship of Shannon, and it decided that biological parenthood may incline an adult to feel a strong concern for the welfare of the child, but that wasn't the essential condition. The person who presumes the role of a parent, the court wrote, raising the child in his own home, may in time acquire an interest in companionship, care, custody, and management of the child. The interest of the de facto parent is a substantial one, recognized by other court decisions, which it cited to. So the status of the parent was decided that the foster parent should assume the role of the parent. Fortunately for the mother, by the time she got over here, 1969, California passed the Family Law Act, or what's become the Uniform Parentage Act now. And in that act, the term that you see often in some of these cases, that you shouldn't remove a child from a parent unless they're unfit. The term unfitness was removed and the term detriment was substituted. The idea was that a child can be placed if it's in the best interest of the child, but a child shouldn't be removed from a parent unless there's a showing of detriment. There were also other laws available. This was before the split of dependency and delinquency. So there were some delinquency laws that were applied, and also Civil Code 4600, which dealt with the award of custody to parents and when that should occur. Because there was never a showing that it was detrimental to remove the child from the mother, the kids were returned to her. She was just very fortunate. She sort of made it, with 2 years before that she wouldn't have gotten the kids back most likely. But this time she did. There was never a dependency case involved in this case. One good thing that, aside from the definition of what a de facto parent is, which appears, I will show you. It should be in the handout, but there it is. Is that the California Supreme Court back in '74 in BG also wrote that we do not hold that a de facto parent is a parent or guardian, as those terms are used in the juvenile court law, nor do we express a position whether constitutional principles of due process or equal protection may require de facto parents in some instances to receive rights of notice or hearing or even the appointment of counsel. So the California Supreme Court found that the children should be returned to mom. Like I said, she was 2 years lucky. The California Supreme Court did, though, go ahead in 1993 in the case of Keisha E. and sort of refined its definition. By that time, there was a recognition after 1976 that parents, well, actually going back to 1923 in the case of Blair versus Robinson, which was a U.S. Supreme Court case, but the concept of constitutionally protected liberty interests were then coming into play in the California law. Because of that, parents were deemed to have, in the family unit, to have an elevated status over de facto parents, even though they had long-term relationship with the kids and may have even been long-term caregivers. There needed, again, to be a showing of detriment to remove a child. And so Keisha, in the scope of its case, wrote that the de facto parenthood doctrine simply is one that recognizes persons who have provided a child with daily parental concern, affection, and care over a substantial time may have developed a legitimate interest and perspective which will also present a custodial alternative, but later on, not during the course of the dependency case. And which should not be ignored, and that it would be important to have that information for the court to make any kind of dispositional findings. But the important thing that was going on between BG and Keisha E is that the court was recognizing that the parents had a superior position to de facto parents in coming into the juvenile dependency court. I know that I've seen, and any of you can make comment if you'd like, just a couple weeks ago when I, as a staff attorney, appointed to do writs, was put into the position of going and covering in court. In another case, there was, oh well. Yeah. Well, they didn't just go out in Georgia then. Okay. That's a tip of the hat to the CMA awards that are coming up. Anyone? Okay, never mind. Okay, but fortunately we have the PowerPoint in paper form in front of you. So, let's see, what was I? When the lights went out. Yeah. Oh yeah. So yeah, thanks. So but after the refinement of Keisha E, the parents now have, that superior position recognized in the law. If you're looking at status and standing page, I did make a typo. The case of Vincent M. should be 2008. It's not 1998. But in that case, it was a second district case, which actually had to do with a father who came late to find out that he had a child. It wasn't so much the holding in that case, but the statement of of Justice Armstrong in dissent, where he wrote that, however, as the court later explained in Keisha E, that standing is limited by the rationale underlying de facto parent doctrine itself. The de facto parenthood doctrine simply recognizes that persons who have provided a child with daily parental concerns or affection and care over substantial time may develop legitimate interests and perspectives, and may also present a custodial alternative which should not be ignored. But the standing accorded to de facto parents has no independent basis other than showing those concerns. So when they come into court and you're at a judicial review hearing and de factos try to say, well, we have standing as full parties in interest, and we're going to show that the parents are bad people, that they didn't go to drug counseling and testing, that they're not involved in, in their parenting or individual counseling. That's beyond the scope that the California appellate courts have allowed for purposes of standing. The status is that the court recognizes that the de facto parents have a relationship and have information for the children. The standing part about the participation, which the court rules allow, is very limited, as those cases show. As we turn the page, what I wanted to do on the standard on appeal is just show that there are some limits that even our clients have. First thing you should know is that when someone comes in and wants to become a gain de facto parent status and then standing, which is a separate concept, we should insist that there be, if it's a motion, that we should be able to oppose the motion. We want to make sure that if there's not a substantially long period of time that the child has been placed with the de facto parent, or the person seeking de facto parent, that we get a chance to object at the time, that the nature of the relationship needs to be demonstrated as very limited, and we want to oppose their status and certainly standing. And so we need to take advantage of those opportunities because, well, then the couple of cases that I mentioned, like in Vanessa Z, there was a baby placed in foster care. More than a year later, the father, who was arrested for selling controlled substances, came back onto the scene. The court denied the applications for de facto parent status, and for his mother, he sought review. The court said that he didn't really have standing to bring anything on behalf of the mother in his appeal because he wasn't directly affected by the denial of her de facto parent claim. The other problems that we may run into is if we don't elevate the status of our clients who may come in only as alleged fathers. The first thing that we should always do is elevate their status from alleged to presumed, if we can, because otherwise they, without any kind of relationship with the child, they have less rights in the case, certainly not to FR. They can't even appeal termination of parental rights. It's more difficult then to make an argument against someone seeking de facto parent status and standing and participating in a hearing when your client's only alleged and has basically no rights at all. Okay, so it's just you should read these cases. Let's see, the next page. Well, I'll do that one next. All right. We've supplied forms for you, JV 295, 6, and 7, which have to do with de facto parents making their applications and seeking a hearing for de facto status. Remember, there's a difference between status and standing. Status is just they're saying, I have a role as a parent figure, I can offer information to the court. Standing is what the court will allow them for purposes of sitting at counsel table, which they're allowed to do. But just recall that de facto parents are not part of any adversarial aspect of the case. That's in Re BF, the 2010 case at 190 Calab 4th, 811. Anyway, again, preponderance of the evidence is the only standard. Recall that in order to remove a child from our clients, you have to show by clear and convincing evidence that there's a detriment. And our clients, unlike de facto parents, are allowed reunification services. That's what our statutory scheme allows them. And we should make that, if the court is allowing the de facto parent to go into all sorts of areas, we should remind the court of their limited stance in the case of in re BF, or status in the case of in re BF. Okay, and now that's all I have. Are there any questions? Anything? Yo. Well, just real quick.
Something interesting, Steve. I mean, not that the whole thing is interesting. But, when you said you're doing a division between our clients and de facto parents, and as you know, when individuals file petitions to become de facto parents, we pick them up.
Right.
So could you distinguish now, when we represent the de facto parent, what we're going to try to do?
Well,
You're going to do it?
yeah.
Got it.
I think maybe questions at the end would be more helpful so that we could get.
She might be covering that.
I think I will be covering some of that. Before I move on to more the practical, going through what you do if you have a de facto or if you're opposing a de facto, I did want to mention, not in our slides, but I think very important to remember going along with what Steve had already mentioned is the case of In Re Alexandria P, which is 2014-228, Calap 4th 1322, which had some very important language in there for limited purposes of this training, the language I'm citing from concerned the de facto parent's challenge in that case to the constitutionality of the ICWA as the Indian Child Welfare Act as a whole. And the court said in that case that there was no independent constitutional interest in the foster family relationship, period, and that the foster parents in that case, de facto parents in that case, had not identified a constitutionally protected interest in a continued relationship with the child, specifically with regards to the fact that the minor did not join. So de facto parents may have an ability to join in a minor's counsel's constitutional challenge or constitutionally protected interest, but they do not have anything independent of the child's rights that they can assert on their own. So that's all I wanted to add. And then as far as moving forward, he did mention already the filing for de facto status form. Usually if we're getting appointed, it's after they have filed for de facto status. I'm going to start with the slide that says, is there any basis to object? And I think I might get into our role if we are representing de facto parents in the second stage. So there's kind of two stages, assuming we're not representing de facto, we're representing parents. There's, can we object to the filing, the initial filing for the request to be de facto parent? And then once they are granted de facto parent status, how can we limit the participation, or what are the rights to participation? So before the status is granted, the court has to consider a variety of factors. Those factors were laid out in the cases that are cited on that page. In Ray, Patricia L., one important, interesting fact of that case that I will just note is that that was a grandmother who had appealed the order terminating her de facto status, even though the child had been out of her care for 2 years. So this de facto status is something that remains in place. If it's granted while the child's in their care, it remains in place until the court makes an order to change it, and it can be granted for former caregivers. So it doesn't have to be the present caregiver who gets de facto parent status. The factors that they laid out in looking at whether somebody qualifies as a de facto parent are, as indicated on this slide, whether the child is psychologically bonded to the caregiver. This is something more than just a babysitter or somebody who's just watching the child temporarily, but very often that will be a foster parent after, say, 4, 6, depending on the age of the child. It's going to change when the psychological bond is established, but they'll often try to establish that with things like, the child calls me mommy or daddy, and indicating all the various needs that they provide for this child. The second factor is whether the caregiver has assumed the role of a parent on a day-to-day basis for a substantial period of time. Now again, I said this doesn't have to be current, so they could have had assumed the role of the parent on a day-to-day basis for a substantial period of time just prior to the dependency case coming in, or years prior, but more likely, in order for the psychological bond to be in place, it'd have to be kind of close in proximity to the dependency case. Case law, unfortunately, focuses on quality versus quantity. An important adverse authority that I didn't actually write down in here is Christina K. v. Superior Court, which is 184 Cal App 3rd, 1463. And I know that we would love to make arguments against de facto parent status, that during reunification, they shouldn't be granted status, that it should have to be a period of more than 6 months before they could be de facto parent status, but those are precisely the arguments that the county and father made in Christina K. And the court said, no, I'm not putting those, the appellate court said there's not these restrictions on it. During reunification is not contrary to the legislative intent, and there's no requirement that it must be at least 6 months because they're focusing on the quality of the relationship, the quality of the care versus the quantity of time. Still make the argument, because I think that, at least in my mind, any relationship less than 6 months, especially depending on the age of the child. If you're talking about a 7-year-old and they've only been in this child's life for 4 months, I don't know how that could really rise the level of a strong psychological bond. When you're dealing with an infant, of course, I think they're going to attach more quickly to a caregiver over a shorter period of time. I think the part about causing the onset of dependency proceedings, we have an extra slide about that, so I'm not going to go into great detail on that issue. As far as the third factor, whether the caregiver has information about the child unique from others in the process. Arguments I would encourage you making in this circumstances: are there already people who are providing this information? Is this child involved with a RAP team? Are we getting, is there actually anything unique coming from this foster parent or potential de facto parent? And have they ever even submitted a caregiver information sheet prior to this application? Any caregiver can provide information to the court without a de facto parent status, without having legal de facto parent status. That's the JV 290 caregiver information form that I'm sure many of you have seen numerous times in your cases. And it sort of calls into question, in my mind, what the motivation is for de facto parent status if there's never been a submitted form before and it's just all of a sudden, I don't know, on the eve of a tutu where mom's going to get the kid back, a de facto parent application comes in. It sort of calls into question whether we're actually granting this person status based on their ability to, as the court has said, provide information to the court and give a full understanding of the circumstance, or if they have some other motivation. The other two are just whether the caregiver regularly attends court hearings and whether a future court hearing may result in an order permanently preventing any future contact with the caregiver. Those are pretty straightforward. I don't know that there's really much to argue. It's either yes or no, they attend them, and whether a future court hearing may result in an order permanently preventing future contact is going to be pretty clear as well. So that's de facto parent status. This, I think, is most likely going to be a loss in many of our cases, because the courts have said you're supposed to grant de facto parent status liberally because they want us to have anyone who has an interest in this child available to provide information to the court. That is supposed to be the role of a de facto parent, information providing. So you're probably going to lose that part. So then, do you want me to do the next two slides?
Sure, go ahead. That's fine.
Okay. We did put a slide in here where there are definitely circumstances where a caretaker will not be granted de facto parent status, and again, that's the quote that I had indicated on the previous page, and in Re Keisha, and also stated in Re BG. If there's any indication that the adult has caused the onset of the dependency proceedings by committing serious physical abuse or sexual abuse upon a child, then the argument is that they have not actually fulfilled the role of a parent. So that would be an objection to the whether they assume the role of a parent, and also an objection to, in some part, the psychological bond. There have been cases, however, where de facto parent status has been granted for non-related caregivers when the child was actually removed from their home because of some abuse. It seems to be that the circumstances where it's not going to be granted are the more extreme circumstances. Just an example of when it was granted is in Rachel C., which was the parents had absented themselves, left a 9-month-old child with non-related caregivers, and the kid got removed from these people because of drugs in their home. And they filed for de facto parent status and were granted it, despite the fact that the child was removed from their home because of drugs being found.
And again, the difference between parents we represent and the de factos like in Keisha E., is that even though our parents may screw up and cause harm to the child, be found to have committed detriment, we're entitled to reunification services because of our status. And if it's a complete violation of the role of the parent, as it was in the case of Keisha E. and some of the others, they'll just be taken out of the picture altogether. So at least we have some benefit when it comes to de facto, making an argument against de facto parent status, and then standing being given to someone who has violated their role as parent.
Then this little slide that says an alternative, I'm not going to read the slide. It's just for your information. It's just an example, an interesting case, an example of where the court actually applied the BG rationale, despite this grandfather not actually meeting the de facto definition. He was not a caregiver, but essentially at a 2-6 hearing, grandfather appeared. He had a legitimate interest in future contact with the child, and he wanted an opportunity to assert his position about why this child couldn't be placed in, or why he wanted this child placed in his care. The court basically granted him like pseudo de facto status, but not actually de facto status. It's just an interesting alternative that we wanted to put in there for you. Now comes the more important part, is the rights to participation. And this entire training is sort of couched in this tone that we don't like de facto parents, but it is true, we do have to sometimes represent de facto parents. So these rights to participation, although I'm calling them limited, they are actually certainly pretty substantial procedural rights that de facto parents have. I called it losing the battle but winning the war. So the rules of court state that de facto parents may do 3 things: be present at the hearing, be represented by retained counsel, or at the discretion of the court by appointed counsel. And number 3, present evidence. Now, the issue with at the discretion of the court by appointed counsel was drawn out in In Re AF, but they actually are citing originally to In Re Joel H, that there is no right to appointed counsel for de facto parents. It is completely discretionary. And case law suggests that In Re AF asked the court to remand for an actual determination as to whether or not the de facto parent was indigent before appointing counsel. Obviously, we don't really go through that inquiry. It's sort of like anybody who shows up and says, yeah, I can't afford an attorney. Like, who knows how much money they have. But, I mean, I certainly think that there could be a objection made if we didn't want to represent a de facto parent, or if it was something that was very contrary to what we represent as ladle. Because, as I indicate in here, de facto parents are not equal to parents. So they do not stand in the same shoes as our clients. They do not have the same rights as our clients. And they are a different animal. They do not have the substantive rights that our clients do. These rules of court only give them procedural rights. They have no right to reunification services, visitation, custody, or continued placement of the child. That's what the law says. However, it seems like sometimes courts treat it a little differently. In that case that I cited there, Clifford S., that was in fact a stepfather in that case who had been granted reunification with his stepdaughter at some point early on in the case with no legal basis. And it went along, and the court terminated his reunification services and said that reasonable services were provided to him and set it to 6. He challenged that as a de facto parent, and on appeal they said, well, you know, it was great that you even got reunification services in the first place, because that's not something you're entitled to, and you didn't have a right to it in the first place, so you don't have a right to challenge the sufficiency of it or the reasonableness of it, and denied his appeal. that case nowadays probably would not even be a common issue, because that stepfather may have been able to apply for third presumed parent status under our new family code 7612C. We've sort of remedied that legally, but still de facto parents have no right to these issues. I think the problem in that case was it was a stepfather, so it created a little bit of a weird situation. When do they have these rights? It's important that case law is very clear that they do not have any right to appear at adjudication. It is only at the dispositional hearing and any hearing thereafter at which status of a dependent child is at issue. They have no right to be present at any hearing prior to that, and no right to assert any position at adjudication. So the next two slides are kind of going to go through a little bit in more detail the actual procedural rights they have and what they really mean. So the next slide, I indicate that the right to be present does not equate to a right to receive documentation. They do have a right to be present and seated at council table as a party, but that is it. It's a right to be physically present. So as a practical purpose, if you do pick up a de facto parent, you immediately are going to want to file an 827 motion, because you're going to need, if you are put in a position to represent a de facto parent, you're going to need access to the juvenile case file, I'm sure, for whatever issue is at hand, whether it be some custodial arrangement for this child or adoptive placement. So the case of In Re BF, I think Steve mentioned it earlier, went in to say that de facto parents' status does not include an automatic right to receive documents filed with the court. In that case specifically, it was the release of mother's psychological evaluation, but they had also, the de facto parents had requested all court documents. And the court had just, in that case on the trial court level, granted liberal access to all court documents and mother's 730 psychological evaluation. That was stayed on appeal. The appellate court said that that needs to be done by an 827 motion, that they are not parties that are included in Section 827 as the list of persons entitled to inspect the file or receive copies, and it's a pretty exhaustive list. So on the one end, if you're representing parents and you have de facto parent counsel who are trying to get documentation, you need to be making objections to them receiving any documents without a 827 motion being filed and granted. On the other hand, if you're representing a de facto, you need to get on filing that pretty quickly, because they do take a little bit of a time. It's my understanding that they can be a month-long procedure to get an 827 granted. Did you have something to say?
One thing that does happen now is some of those, there are some private attorneys representing de facto parents who say, just as an example, at the conclusion of the 21F hearing, they get a ruling that the child's supposed to be returned to the parent. The de facto parent has had the child placed with them since the case began. What they'll do is file a writ of supersedious. What the court rule is that the 827 motion had to be accompanied by the filing, just of the notice of intent to file the writ. The appellate court said, no, you have to accept the notice of intent to file the writ, or writ of mandate, and you don't need the 827 request. So the writ of mandate or the notice of intent went to the Court of Appeal, and it's there that there was some agreement between our court and the Court of Appeal that the foster parents were then able to go to the Court of Appeal and look at all of these documents. So, the issue's going to have to be resolved. So what you need to do is talk to your firm directors or talk to your writ attorneys also and see what might be done. I don't, as the writ attorney in the Iglesias office, I'm not really comfortable taking a writ of supersedious on behalf of the foster parents, if we're representing them as foster parents, to try to get, to go against the main body of our clients, which is the parent of the children. So I know it's under our contract with the Judicial Council to represent them, but it really puts us in a difficult position, having to represent them. I can see us representing prospective adoptive parents because usually there's already been a termination of parental rights, but earlier proceedings to represent de facto parents is, puts us in a difficult position. And the de factos also want a lot more work done, want a lot of one-on-one attention that, with 300 cases we don't always have an opportunity to give. Maybe that will encourage them to go out and spend some of their own money, or have the FFAs put up money for them to hire their own counsel. And that's my editorial comment. So.
Just one more note about In Re BF. Which I'm going to get more into on the next page anyways, is that the court specifically said that the de facto parents, with regards to the psychological evaluation, there was no reason that they could presume, even had an 827 been filed, that was relevant or necessary for the de facto parents in asserting their role to provide information to the court about the child. Because they said it was not the de facto parent's function to rebut the psychological evaluation information. That there was that the information given by the mother to the psychological evaluator would have been, her credibility would have been assessed by the psychological evaluator, her credibility would have been assessed by the social worker who had also interviewed her, and it was not the de facto parent's function to do that. Their function in that case, and as many of the cases have tried to clarify, was to provide information and give a perspective to the court. So the next slide is the right to present evidence is not unfettered. There, in that case, in Re BF, there is some very nice language that says that the de facto parents are not part of any adversarial aspect of a dependency case. Now, while that's great language, if you want to throw it into some sort of written motion or objection, we all know that the de facto parents oftentimes in practice in our cases do become part of the adversarial process. They have an attorney, many times private counsel, who are calling witnesses, who are cross-examining the social worker or witnesses in the case. However, this is meant to help us try to, like Steve said, make these objections so that perhaps this can be taken up in the right case and clarified in a better way. I indicated that their role should be more informational than adversarial, as I already said. And the theory of it being granted liberally is that the court only benefits from having the information about the best interest of the child. That's that information that usually is presented by way of the caregiver information sheet or sometimes through their de facto parent status application. Their role is limited. As I said before, they do not enjoy the same substantive rights as parents, and they do not enjoy the same due process rights as parents. So I give an example of a comparison of Rule 5. These California Rules of Court, 5.534E, where they say that de facto parents may be present at the hearing, be represented by counsel, and present evidence, with Rule 5.534K1B, which specifically says parents and children only have the right to confront and cross-examine the social worker and other witnesses. Now, in Re Damien B that I wrote here is a case where the appellate court, the de facto parents basically appealed the trial court's decision at the contested 2-2 hearing where the child was eventually returned to, I believe, the mother, because the court denied them the opportunity to cross-examine the social worker in that case. But the court accepted into evidence and for consideration with almost as a declaration the caregiver information forms that were submitted by the de facto parents. They had submitted, I think, a series of caregiver information forms, caretaker information forms, indicating what they thought the child's unique medical issues were, why they thought mother would not be able to care for this child. They indicated in these caretaker information forms the doctor's appointments that mother had missed, and the doctor's appointments that had taken place without mother being there, and all the things that they were doing for this child that gave them concern about this child going back to the mother. They, through their counsel, adamantly requested to cross-examine the social worker, and the court went through an extended, the trial court went through an extended back and forth with de facto parents' counsel for some sort of offer of proof as to what was that, we're not here to prosecute, you're not here to prosecute the parent, what was that, what information were you hoping to elicit from that? And counsel couldn't really come up with anything that satisfied the court and that wasn't already in the caretaker information forms. They wanted to cross-examine the social worker about all the appointments mom missed. They said, we have that in your form. And the court found, the appellate court found ultimately that the de facto parents had not been, quote, shut out of the dependency proceedings. They were allowed to present their information as is their procedural right, and that's all that the court needed from them. However, there is also the case of In re Matthew P., which I think the distinguishing factor in this case is that in this case, the appellate court found that the de facto parents' procedural due process rights were violated, where the de facto parents were not allowed an opportunity to cross-examine the social worker. And this was not a contested 2-2 where mom was trying to get custody back. This was on the de facto parents' 388 motion. So it's a little different, and I think you could distinguish the two in that way. That I think that perhaps their right to present evidence is a little bit more expanded when it's their own motion that they need to have some ability to meet their burden. And if the court was only going to rely upon the social worker's reports in denying their motion, the court said that they needed an opportunity to at least cross-examine the social worker regarding the reports in response to their 388 motion. I think finally, I think I already touched on this a little bit, but when does it end? It is really important to note that it does not end. And I cannot stress, when the child is, say you're at a contested 388-26 and you've got de facto parents, you win your 388, the kid gets returned to your client. De facto parent status does not terminate by operation of law. The only way it terminates is either by a 388 motion or by termination of dependency proceedings altogether. And I don't know if there's really that much more to say on that. It's our normal 388 standard, changed circumstances and best interest of the child. As I mentioned before, in re AF, where grandma had had the child for, I think, like 3 years. Kid went back to mom. Mom messed up, relapsed. Kid went to an aunt. Aunt did something horrible. And then the kid ended up in a foster home. And there was 2 years lapsed in between the last time that grandma had custody. However, that entire time she remained a de facto parent because it was originally granted back when she had custody. The court never did anything to terminate it. Nobody ever petitioned to terminate it. So she jumped back into the picture as a de facto parent 2 years later down the road. So it is really important. You don't want to keep that door open, especially if you end up getting your client's kids back. It's probably not going to be something that you can immediately petition to terminate, although perhaps you will, because courts have said that the loss of custody alone does not make it a non-issue and does not necessarily by itself render the 388 burden met, because there's still this issue of if a child was just removed from de facto parents, there's still probably a psychological bond there. I mean, they're still probably, and they are not the current caretakers, but they were a former caretaker. And although they're not presently the day-to-day caretaker, they were a day-to-day caretaker. So, just, it's a case-by-case basis, but, you know, it may take a little bit of time after the child's return, but I would definitely not wait too long to file that 388 and craft it appropriately. Any questions?
Is BF the case that says de facto parents aren't allowed to become another adverse party like county council?
Yeah, that's
BF. That has all that good language in it?
Well, you're talking about the 1974 case?
that they're
No.
not part of the
I'm sorry, that, or BF.
BF is the
BF is the
okay.
one, yeah, not BG, but
That is the
BF.
one?
Yes.
That's the one where I said that that was with regards to mother's psychological evaluation. They did say that it's not the function of the de facto parents to be rebutting the psychological evaluation information or prosecuting the parent.
But didn't they also say the parents don't need one more person to be battling against? De facto parents are just to bring in information?
Yes,
Okay.
that is the theme of it.
Here's a question. What would you guys recommend? Like, so let's say that you're in trial on a contested discipline, for instance, and you have a de facto parent at the opposite end of the table. And they attempt to cross-examine the worker on issues that you think are adversarial. What would be the appropriate objection to that? Lack of standing or?
Yeah, and I also go
I
with
would-
relevance as well, you know. But it's certainly, you can cite to some of the cases that we've gone over
And I would-
for limited standing.
I would lodge your objection before they even get the opportunity to cross-examine the worker. I mean, I would say they are more than welcome to sit here as a party at the table, listen, present information as they have it, but cite to the cases and information we've given you that maybe they don't and shouldn't have a right to cross-examine the social worker if they've been able to, you know, what is the offer of proof, why do they need to be getting into that? But yes, I would definitely make an objection.
So anybody else? No? Okay, so, I mean, it's just like we said at the beginning, de facto parent status is one more little side issue which you really need. We put a little more information into the PowerPoint than normal, so you can carry this document around with you in your specially marked folder, de facto parent status and standing. And you can cross our names off and put yours, and you can share it with friends. And also, if you want to forget about what we've said today, just like in Harry Potter, you can get your wand and just take the little thread of memory out. You know, the same one that helped Harry remember what happened at the trial of Sirius Black. So, and that's a Harry Potter reference from the Goblet of Fire. And anyone? Okay. Okay. Thank you all very much for attending. Oh, and I know that you want your this stuff. Okay. Okay. I'm just putting it.